Welcome to all to Rising Edge TV. Today we're launching our new series, the D&O Files. This is where you're going to learn about what can go wrong in the corporate scandals and the role that insurers and the brokers, solicitors may have in resolving, addressing, mitigating a situation, hopefully through the use of a decent D&O insurance policy. So today, joining me for this panel, we have Ed Smerdon. Ed, you are a solicitor and director at Coverage Matters, and you are specializing in D&O wordings. Next to you, Ed, we have Francis. Francis, welcome. Francis Kean, you are a partner with the financial line teams at McGill and Partners. And next to Francis, we have James. James, welcome to you as well. James Cooper. James, you are a partner at the law firm Clyde & Co. And last but not least, our very own Owen Dacey, that many of you know from the very famous D&O podcast of Rising Edge. Owen, you are our general counsel, so I speak under your control, and you are also our head of claims. Welcome to the four of you for this panel. So we thought that actually it would be interesting to see the efficacy of D&O insurance through the lenses of corporate scandals, hence opening the D&O files, and today we're opening the files of Carillion. So Ed, as a start, can you please, bring everybody on the level playing field, tell us a little bit more about this case? What happened?
Thanks, Philippe. It's a really interesting case, actually, and it's probably one of the biggest and most noteworthy corporate collapses in the UK in recent years. Carillion collapsed fairly spectacularly at the beginning of January 2018, and really a year before that, there had been very few signs of any problems. So you can see that in a year, the company went from being very strong looking to collapsing. So you know immediately there's something badly wrong in the company when something like that happens. So at the time of its collapse, it had debts of £7 billion. It employed 43,000 people, all of whom eventually lost their jobs. 18,000 of those were in the UK. It had grown very quickly over the prior 20 years. It had taken over some of the other household names in the construction industry that we're familiar with, like Alfred McAlpine, Molam. And so they looked strong. They weren't just a construction company. They also were a services company. And in those various roles, they were a household name. They had a lot of government contracts, which I think made them especially noteworthy. But also, they were involved really in all the towns and cities of this country. They built schools, hospitals, prisons, airports, railways. They were involved in all of them. I remember hiking up to the top of Mount Smerdon one year and was looking forward to a cup of tea and a biscuit at the top, and was faced with a building sign with a huge Carillion sign on it, because the cafe was only half rebuilt at that time. So I realized, just from my own personal experience, how common Carillion was across the country. So it really was a big deal when it went bust. But at the end of 2016, when it published its annual report and accounts for 2016, everything looked pretty rosy. And indeed, they paid a dividend to the shareholders in the middle of 2017 of 55 million. And you don't pay a dividend unless you're confident that the company is a going concern. But at that point, it appeared that there had been some queries raised internally about revenue recognition and cash flow in particular. And it seemed as though that a lot of the contracts they were involved in, a lot of these very lucrative looking contracts they're involved in the UK, Canada, Middle East, they actually were not paying as they should be. The revenue from those contracts wasn't flowing as well as it should have been. And it might have in some cases been overstated. And there wasn't really any provision for those contracts not paying what they were supposed to. So there were some queries being asked about internally by the accountants. And as a result of that, they had an investigation, and they released an H1 half-yearly trading update, which is an unusual step, and a profits warning. And in those documents, they disclosed that the CEO had left the group and was being replaced by the senior independent non-executive director, which again is a dramatic step without any warning. They also mentioned that they were going to cease trading in certain places, and they weren't going to take a lot more Middle Eastern business. And probably the most important part of that trading update was the impairment charge of more than £800 million. An impairment charge is essentially a warning to the company that they're not going to recover everything they thought they would recover on their contracts. So immediately it was sort of like a bad debt. So in that case, the company was in much worse shape than people had expected. And this was a surprise to many in the market. As a result of that, the share price dropped on the day of the announcement by some 30%. And again, over the following days, that 30% turned into 70%. So the share price really started to take an enormous hit because of this bad news. Soon afterwards, the finance director, who hadn't been in the role for very long, he'd been in there since the beginning of 2017, he was fired. And then E&Y were appointed to help the group try to find more finance and to stabilize the cash flow, chase debts, and try and get a better idea of where the revenue was coming from. But after many attempts in the last few months of 2017, no more financing was forthcoming. They obviously went to the government because they had so many contracts with the government, and it was to be the government in a way that we most inconvenienced by Carillion going bust. But the government didn't make any significant contribution to the financing. So really, by the end of 2017, the company was thinking there was an air of inevitability that the company was going to go bust. During those last couple of months, the impairment charge had gone up to more than £1 billion. So it was quite clear that things were getting worse, not better. More information was coming out. And it was also clear that in the first half of the year, they'd made a thumping great loss. The company made a really big loss by comparison to 2016, where it had made a healthy profit. So again, this tends to suggest that the situation hadn't really changed in the company, but the information had got much better about what was really going on. And that was causing these updated numbers, and it was causing the tanking of the share price. So essentially, we arrived in the beginning of 2018 with a very difficult situation. And the liquidators were called in the middle of January 2018. And really the rest is history. I'm sure we'll get on to talk about the fallout after I finished here.
So thanks, Ed. That's but so far it sounds very much kind of like a corporate collapse. I don't hear so far kind of like what actually went so terribly wrong. But I guess something must have happened already at that stage. And since we're here to talk about D&O insurance, I'm turning to you, Owen. At that stage, I would imagine that notification must have been given to the market. What are kind of like the initial stage of what would have happened at that stage from an insurer standpoint?
Well, yeah, thinking in theory about what would happen in that scenario where there is a company on the cusp, maybe, and then in liquidation, I would expect the first port of call to be the insurance broker. Well, first you need an awareness around that there is something that perhaps you might need to update the insurer on or notify the insurer of as you're sort of leading up to that collapse. And then the first port of call, of course, is the broker, and a review of the policy terms and conditions, what needs to be notified, what kind of information would need to be presented. And then the broker and client would probably then be working to get information and think about how that's going to be presented to the insurer in some sort of notification. It might be, if there are no claims yet, it might be a circumstance saying this is happening, this is unfolding, there could be claims, so we're letting you know. Or when there are claims, of course, it's getting the claim documentation sent over to the insurer as a notification.
So by now, people start to talk about it, right? In terms of, because it's high profile, as you said, and so there's like something brewing, right? Mm-hmm. But then the situation gets even worse, right? I mean, so what happened that actually makes this case quite particular?
I think one of the interesting things, and in a big D&O collapse, you'll have a number of different things that start happening, and I'm sure the others will talk about those. But the very first thing that happened with Carillion, which was interesting, really because of its government involvement, was a parliamentary inquiry, and those you don't have those in every case. This was particular to Carillion because of its involvement with the government, and it was such a high-profile collapse, and so many people were affected by it. that it really had to be a parliamentary inquiry. There was a joint committee set up, and the directors were given a good old grilling by the MPs. Yeah, that's what happened.
Yeah, I understand. It makes it interesting watching even a few years after the fact. So indeed, let's not forget that D&O insurance is about the Ds and the DOs. So you did mention that, now individuals are being called and have to explain their decision making. So maybe turning to you, Francis. So what can you tell us in terms of like the from your experience? How can you go from bad to worse? Like what are the missteps that are being taken, maybe in that particular case, or things that you have observed more generally?
I think the first thing to say, Philippe, is that insolvency is the worst possible nightmare for the directors, and for two main reasons. One, because if you're a director, you would normally not bother yourselves, I suspect in most cases, with the terms of your D&O insurance. You rely on the company to make sure that your defence costs were paid in the event that you got sued. You probably have an indemnity from that company, and the D&O insurance you might be aware of, but it sort of sits behind all of that. Of course, when the company goes bust, that indemnity immediately becomes worthless because the company has no money to pay it. That's problem one. And problem two is that the company is now in the hands of the liquidator. And so instead of it being a normally run company where you have a responsibility as a director to report to the shareholders in annual general meeting, you now are responsible through the liquidator directly to the creditors, and the company has become a vehicle through which that responsibility can be litigated. And that's indeed what has happened in the case of Carillion, because beyond what Ed was describing, which was the first stage, the Parliamentary Select Committee interviews, there were then the inevitable interviews by the liquidator, which they are statutorily required to do, of directors. What on earth happened here with this company? How could this have arisen? And those directors need significant legal representation in the context of those interviews. That costs a lot of money. Those interviews can then be used or replicated by regulators and potentially ultimately by claimants in future proceedings. So all of that is going to be hugely expensive so far as the directors are concerned. And as I say, the company has shuttled off the mortal coil. So the only show in town at that point is the D&O policy.
Francis, do you feel that this comes as a surprise to directors in your experience in coming through claims, not realizing that actually the safety net of the company through that indemnity disappears in case of insolvency, and therefore how critical the D&O insurance policy is actually to help them and also to protect their own personal assets? Because unless mistaken, their liability is unlimited, right?
If they had paused to think about it and they were sitting around a table similar to this, then no, it wouldn't come as a surprise to them, because it's an obvious logical effect of the company ceasing to exist. But it nevertheless is always a shock to them, because the practical reality of it is so stark. And it leads on to a consideration, and I'm sure the others around this table will have some thoughts on this, as to the adequacy and effectiveness of the D&O insurance suddenly, which is a product that's bought by the company on behalf of its directors. Now the company has shuffled off, and it's only the directors who are having to deal with the insurers. And there are some consequences of that in terms of coverage that I think fall into three main categories that directors would be well advised to give careful thought to before they are unfortunate enough, if ever this happens to them, to be involved in an insolvency where they are still on the board.
So I can already hear in the distance the solicitors kind of like circling around, right, James? Because I mean, between like having the notification going on, I guess. I mean, so firstly, help us understand kind of like the geographies of solicitors involved in a case like this. It's just not like one set.
No,
there are quite a few that are kind of going to be involved in that scenario, right? So can you list us a little bit who gets involved in representing whom at that stage?
So often the first firm that will get involved will be the firm that acts for the liquidators. And so they will almost certainly have a law firm retained quite quickly. And then it's for each individual director after an insolvency to think about their own personal position. And I think, again, as Francis said, there are some differences when companies go insolvent and how D&O responds, because in that situation, you tend to find that most directors will quite often, certainly at an early stage, go off and appoint their own individual law firm. So you can have multiple law firms involved quite early on, which then means that maybe the coordination isn't always there as you would hope. That can then sometimes streamline down a little bit later as people start to understand the universe of the claims that they're potentially facing, the investigations that they're facing, and then they can get comfortable that actually they're all aligned and you can get behind one law firm. And then sometimes the carrier, the insurance carrier, will also appoint a law firm to help them navigate, usually not so much the coverage points at that stage, but just how are you grappling with lots of invoices coming in, how you're grappling with protecting privilege around all these individual law firms, etc. So you can see law firms getting involved in 3 different areas: for the liquidator, for the directors, and then sometimes for the carriers.
So the scene is set. I think the main characters have showed up, right? We have a bunch of directors. We have some insurers in the picture, the brokers as well, having handled the notification, kind of like in a set of solicitors around. So now we start getting to the meat of things. So Ed, coming back to you. So I guess we're getting into that discovery stage, right? I mean, a member of the Parliament asking questions, the liquidators asking questions and all that. So we're starting to peel the onion, right? I mean, so what are we finding?
Well, in this case, of course, it was really the first public statement by the individual directors as to what happened, and they were given very uncomfortable. They were given a very uncomfortable ride by the Parliamentary Committee. So it certainly at that point they would have, as Owen mentioned, they would have notified their insurers, and they would have been looking for their costs of being advised in relation to that committee and their responses to it. So what they don't want to appear like in those committees, though, is relying 100% on their lawyers, because that looks as though they've got something to hide. So in the end, they give a fairly sort of open appraisal of what happened, and as a result, the committee issued a report in May of 2018, which was pretty damning.
So what did it say?
Well, it said that the directors essentially were mostly concerned with their compensation, and had acted recklessly in relation to the management of the company and its affairs, and had ignored warning signs, and essentially had mismanaged the company in a fairly dramatic way. That was the sort of summary of what they said. There were a lot of comments made in the report, but that I think would be a fair summary of what they'd said. And they also mentioned, which I think is quite unusual, that the Insolvency Service should look into whether there had been a breach of directors' duties, and whether or not it was appropriate to seek a disqualification order against those directors. So you can see that's quite a dramatic step fairly early on in the proceedings, because the meetings that Francis mentioned with the liquidator, they would be private. So although they would have had meetings with the liquidator, with lawyers, the outcomes of those meetings wouldn't be known publicly. They might be recorded, and as Francis mentioned, they might be used against the directors in the future. But the first real public assessment of what happened was the Parliamentary report in the middle of 2018. And of course, that set the scene for what then happened next. You get other people getting involved, and the next people to get involved were regulators.
So from the description of this case, this is not kind of like an unusual insolvency, though, because of its size and how quickly it came, right? Because you were saying that just a year before, they successfully renewed their D&O insurance policy. So I guess whatever was represented and analyzed by the underwriters seemed okay. They distributed a dividend mid-year. So everything kind of like, so it's a sheer size and speed of how things melt down. And I would imagine at that stage, the directors that are kind of like front line of the kind of like answering questions, has there any been kind of like finger pointing started among themselves? So if we can't comment specifically about them, maybe just generally speaking in terms of experience, and therefore when you said that they each tend to appoint their own solicitor, James, in your experience, do you see that finger pointing starting to have issues about conflict of interest, in terms of like different strategies, in terms of defense strategy? It was not me, it was him. I did not know. I could not know. I was not told. I asked the question, but I was not given the answer. I mean, how ugly does it become? And does it become ugly frequently, or is it kind of like particular to that case?
Yeah, I think that's an interesting point, the frequency, because when it gets ugly, it will get very ugly. But in my experience, I wouldn't say it's frequent. I think quite often you will find that the board sticks together, that they don't see a conflict of interest, that actually they put forward a unified defence. And so, yes, mudslinging starts, and sometimes you see people peel off the edges, but I would say that's not perhaps as frequent as you would think. I think when you see something the size and the complexity of Carillion, and particularly the Parliamentary inquiry getting involved so early, it was perhaps always going to get a little bit messy, this one. But the vast majority of cases, I wouldn't say you have that frequency of conflict of interest, or certainly not a conflict of interest that arises early. Sometimes you'll see it a little bit further down the track, where the liquidator will start asking particular questions, or a creditor brings a claim which perhaps focuses on one individual or the other. And sometimes you'll see the civil claims may only implicate one or two directors and not the rest. So what do the rest of the board do, etc. So it's not perhaps as frequent as you think, but when it does happen, it does get very ugly and very expensive. And that's when you start looking at things I'm sure Francis is going to come on to later, about how do you protect the limits of a policy when you have quite so many law firms involved, where there is either a conflict or, even worse, just simply a perceived conflict. And you as the carrier and the broker are trying to manage that to make sure there is enough policy there to protect the people in the way that they should be protected.
So we'll come to that indeed, James. It's really interesting because, at the end of the day, insurance is to deal with the unforeseen, unusual, kind of that, not the usual occasion, right? I mean, so this is at that stage, indeed, Francis, that actually it's the acid test for the insurance policy. Is it fit for purpose? So before we even talk about the limits, let's consider like how it actually responds in terms of like when you have all these directors coming in and saying, I want my own set of directors. I want to solicitor, forgive me. I want to appoint them myself. How do insurance policy respond to this?
I think, in fact, there's a prior question to that, which is more existential around the nature of the cover and whether there actually is cover for all of the directors. But just before I get onto that one, I agree with everything James said, so far as the number in practice of situations where there are conflicts so that the limit gets eaten up more quickly than you would otherwise expect. But I think it is worth making the general point that there is a natural divide, not least in terms of the allegations that generally are faced by directors between the execs and the non-execs. Because the non-execs typically are faced with the allegation that they were asleep on the watch, that it was the execs who had all the egregious conduct or didn't do what they should have done, but it was the non-exec's job to tap them on the shoulder and ask them and look in their eye and ask them what they've been up to. And so if you wanted to take a rough rule of thumb in terms of perhaps different interests needed in order to pursue defences, you'd look naturally at that divide between the execs and the non-execs. That's as a general thought. Going on to the coverage question and reverting to what I said about the existential question before you get on to the fine detail as to whether there's cover for individual directors, and if so, what for. The existential question really stems from something that Owen was talking about around the fact that something would have been notified, one hopes, at some point, and in Carillion, perhaps before the insolvency balloon went up. But it really does matter what was notified, because these policies all operate on what's known as a claims-made principle, which means that they only respond to claims made against the directors during the 12-month period. And yes, you are allowed to notify circumstances which may give rise to a claim in that period, so that you have the ability, if you can foresee circumstances which may reasonably give rise to a claim, to attach that future claim to the policy while it's still alive. But if you think about it in terms of insolvency, there's a lot of luck involved, because if the policy runs from the 1st of January to the 31st of December, and the company goes bust in November, you've only got 2 months left in which to notify all the circumstances which could give rise to a claim. The fact that the company has got insolvent isn't itself, I don't think, a notifiable circumstance. And you may well be struggling to be able to foresee in a way that will persuade insurers all the things that can happen down the road. And let's say some unexpected litigation is instituted against the directors a year after the liquidation. And after the policy has expired, in my example, the December time, there ain't no policy left to attach that claim to. And so the real threat for the directors, the most immediate and dangerous threat for them, is that the policy will expire without them having effectively attached, through a notification of circumstances, everything which could in the future. And Ed talks rightly about the disqualification proceedings that were first mooted in 2018. They're still going strong now, and the trial hasn't yet got underway for some of the directors of that disqualification proceeding 5 years on. So all I'm saying is it's very important that everyone focuses on the expiry of the policy period, because if you're unlucky to have the insolvency shortly before the expiry of the policy period, and you haven't really carefully instructed lawyers to help you notify everything that can be notified, you will find yourself not just looking at whether there's coverage or not, but actually having a fight with insurers about the fact that there is no cover for this particular claim because it doesn't attach to the policy.
So Francis, at that stage, I would imagine it must be a bit of a difficult job for a broker to go back now to the insurer and ask for an extension, knowing that actually the house is on fire, but the notification hasn't kind of been made, or kind of maybe that's not reasonable for some reasons. So it must be difficult to kind of get an extension.
Not just a difficult job, it's completely impossible. It can never happen. No insurer would grant an extension in relation to a company that's gone bust. And there's no money to provide for a new policy. But even if there was money, insurers wouldn't be prepared to accept it, because they would just regard it as throwing it away for a certain limit loss. So it really is existential that everything is notified to the policy in the year in which the insolvency occurs. Otherwise, there's no other show in town, unless you're fortunate enough to have a policy that allows an extended reporting period. And that is possible, but far from uniform. So some policies will allow, in the event of an insolvency, you to notify claims up to 6 years after the policy expiry. And that, if I were a director and there was any hint of the conceivable possibility that the company might go insolvent, that's what I would want as one of my main asks. Because, as I say, why you buy this policy is just for this sort of scenario, because otherwise, if the company's around and solvent and you've negotiated a good indemnity, you shouldn't as a director ever be troubled with any of this stuff.
And James, I suspect that for many reasons, the company cannot either set aside funds for the future, carving out kind of like putting them aside for only the purpose of defending the NEDs. That money goes into the general pot to pay for creditors. Is that correct?
That's correct, yes. And the company, as Francis said earlier, the company isn't your game in town. It doesn't exist anymore except as a vehicle. So it can't help you anymore after it goes into insolvency.
So Ed, I mean, is the industry providing product fit for purpose here?
It's a claims-made policy, as Francis mentioned, which all directors and officers liability policies are. And it is possible, as Francis mentioned, to buy extended reporting period. What's quite interesting is that you don't see an automatic extended reporting period for insolvency that often in these verdicts. You'll see a baked-in extended reporting period at the end of the policy period if it isn't renewed by someone. Of course, it isn't going to be renewed if the company has gone bust. So in theory, it might be possible to trigger an extended reporting period, the existing one of maybe 1 year that's in the policy for non-renewal, as long as insolvency isn't one of the events which is an exception to the offering of that extension. So, for example, the definition of a transaction in the policy, which is usually a takeover or a merger, that doesn't usually generate an extended reporting period automatically. And if that definition also includes the insolvency of the company, then that right to look for an extended reporting period at the end of the policy period for non-renewal doesn't exist. So you do have to look very carefully at the terms, but I think that the market is willing to embrace these situations because the market wants to provide a product that is useful to the directors and is there when the worst happens. That is the general perception of the market, and you still have to look at the terms and conditions to make sure that that is actually what will happen if the worst happens. So I think that there is definitely an intent behind providing the best possible cover for directors in an insolvent situation, but they are complex problems, and we've mentioned some of the policy issues that arise, but there are usually quite a few policy issues that arise, and you have to look at the terms and conditions of the policy when you're buying it to make sure that those types of situations are going to play out in a way that's expected and not unexpected. Otherwise, you will have a dispute.
Oh, and turning to you as a very experienced claims handler, clearly, when I was asking whether the product is fit for purpose, I mean, there must be some purpose that is being met, just judging by the amount of claim that actually the industry pays out. So
yes.
So somehow that is a good test of like something can kind of works. But in your experience, maybe back to the point of the limits. As the insurer, when you have everybody coming to you to fight for a limited pot that may start to be seriously depleted, or when you already know based on the way you sit that this is what we call in the industry a full loss limit, i.e. your full policy limit will be burned through this, how do you determine who to pay with that limited amount of fund available?
Well, I think it starts with the process. I think when that situation arises with multiple people, with multiple lawyers, it's about expectation management. It's about everyone understanding how the policy operates, and you're basically coordinating. So I think you have to, some law firms have done work for insurers before, some others haven't. Some know about the consent requirements, some don't. But I think if you do the upfront work in terms of setting out the expectations from each law firm in terms of, you need consent, you need a budget, this is the limit, and you manage that appropriately. That's the best you can do, basically. You can't just favor someone over another person. Everyone has to kind of play by the same rules. And so once you've gone through that budgeting process, the approval of the budget, working through the strategy and agreeing the strategy, those kind of key phases after coverage, obviously. There is then another process, of course, where the bills come in and they all have to be reviewed again, kind of fairly across the group in terms of what is covered under the policy according to, what's reasonable, etc. So I think there's just a lot of upfront work in terms of managing expectations and setting out your own expectations about how the policy is going to respond to them.
And James, so from your perspective, in terms of that kind of like debate about the limits, invoices being paid, not paid, prioritized, how is your experience in terms of like the engagement that you have with the liquidator? Because I guess that one of the first phone calls they must make is to figure out what sort of D&O insurance is available.
They like to know because they'd quite like it, please, to put into the pot for the creditors. So we would always try to an extent, keep the liquidator at arm's length because they're not they may essentially legally be the policy holder, but they're not now the people taking the money from the policy. So it's much more about engagement with the directors who are then the insured persons seeking the indemnity and their law firms. So we we would be quite resistant to having too much engagement with the liquidator for that reason. And so it's much more about how do you engage with the law firms, as Owen said.
Francis.
Two quick points. One a practical one going back to my theme with the non-executives. The practical one, going right back to what I said earlier about the company not existing anymore, is that when Owen and his counterparts because bear in mind that these are often towers of insurance. It's not just one insurer you're dealing with, it's several insurers, or could be many insurers. When they start asking questions about fees about the lawyer's fees, and that can be quite an extensive exercise to justify the fees, and that's a perfectly legitimate thing for the insurers to want to do, not least in order to preserve the limit. Nevertheless, the task of doing that is not something that's covered under the D&O policy. The company, as we've discussed, is no longer there to foot those sort of coverage costs. And so the only source for the time spent in dealing with insurers is the director's own pockets, because that's not something that's covered in the D&O policy. So that's another thing that could be a nasty surprise for the directors. The other point I was going to make about the non-execs goes back again to what Owen was saying, where you make everyone aware, as he rightly said, what the limits are and how you go about, what hoops you need to jump through in order to get your bills paid. But the general rule of thumb in all these cases is first come, first served. That's how the limit gets eroded. And if you think about what we were discussing earlier about the executives having to bear the main brunt of the regulatory investigation, the parliamentary investigation, the proceedings, whatever else it may be, they're going to be using up the limit because they're going to need to spend the money rather more rapidly and extensively, perhaps, than the non-execs. And so the non-execs might be watching rather nervously the rate at which the limit is being eroded by the execs. And so in discussing and deciding what the appropriate limit is, long before the company goes bust, it's worth the non-execs bearing in mind that first come, first serve could see them having the limit substantially eroded before they have to start incurring the costs of dealing with the accusation that they were asleep at the watch.
That's a really good point, actually. The most policies do actually have an extension for the non-execs, just as a special excess limit, which when the whole tower has been exhausted, the non-execs can tap into a special extra layer of insurance on the primary policy, and it may go up the tower, that coverage as well, which then essentially is just for them. And it is exactly the situation that Francis was talking about, which is that the limits tend to get burned most vigorously by the execs quite quickly. That's where a lot of the main action is. And the non-execs is more of a slower burn, the claims for them. And so they have that extra limit potentially available to them if the limits have been burned by the time things really hot up for them. That said, in my experience as some claims coverage lawyer, I never saw that extension ever actually triggered. I don't know if anyone else on the panel has, but I've never seen it. Although Carillion might be the case. It might be the case, because the non-execs are still very much in the action right now with the disqualification.
So we're not going to put you on the spot to answer that question because it may...
No, I mean, I was just going to say, I'm not talking about Carillion, but it has happened, and I have seen cases where an entire tower has virtually been eaten up by a single executive. So it does and can happen. And of course, when you think about the pace of regulators and how long these things can take, so 3 to 5 years, I don't think that's even that long. These things go on for longer. So it's absolutely possible that it can happen.
So precisely, I mean, it goes back to kind of like the conflict of interest, or certainly maybe diverging strategies in defense strategies. So James, have you seen these cases where basically the interest of some directors, execs or non-exec, is actually to settle early, admit liability, just get on with their lives, versus some that actually have far more at stake to having a favorable outcome of the process, and therefore are playing the long run game? And it seems, without just looking at publicly available information again in the Carillion case, it seems to be the case because some directors have actually settled early, so they get into a slap on the hand quite severely. I think some significant fines, disqualified for 10 plus years, but at least they can move on with their lives. When the others, they will be still they're still going through the process. So in terms of that conflict, I mean, so have you seen this? Is it happening? How does it get resolved?
Yeah, so we've definitely seen it a few times. We had one actually that settled fairly recently, where we had 4 directors, all with proceedings for disqualification against them, and it was very clear that the case was better against some than the other. They had 4 different law firms. They had very, very different defence strategies. Some of them wanted to run really, really hard to try to force the Secretary of State to discontinue. Others wanted to go a bit slower to see whether they could reach a settlement which had a slightly lower period of disqualification, for instance. And so, yeah, trying to deal with that is really difficult. And the policies aren't really designed to do that, because in some ways the policy is there to provide an indemnity for an individual. It's not always there to necessarily deal with how do you direct the strategy of a case. That's for the lawyers who are retained. It's not for the insurers to make that decision. It's though about the conversation with the insureds, with the lawyers, and in particular with the brokers about you're a real risk here of using your limit. You've got to start to get to grips with this as a whole. And that's the assistance that a good carrier can bring, but it isn't something that the policy is actually designed to deal with. That's very much, I think, one of the roles that the brokers can play in this, because they are the one person who's really deep into what each of the individuals should be doing and thinking.
Francis, I mean, do you, in terms of like sitting as a role and representing here the brokers, how do you kind of like engage then with the clients that actually, for them to really understand all the ramification and how critical this is going to be in the few rare instances where it's meant to kind of protect the personal liability of the directors? How difficult a job is it?
I always say getting the attention of the board is my biggest challenge, rather than looking at competition in the broking industry. It's focusing on the end users and getting the directors to start thinking about these issues rather than simply assuming, as is perfectly natural while the company is existing, that they don't need to get into this level of detail. Insolvency is the game changer, and if I had the ability to do so, I would certainly recommend that all boards had a little sort of teach-in or discussion around what the implications of that are for them, some of which are emerging in this discussion.
Clearly. Ed, your perspective on this?
I don't disagree with anything that's just been said. I think if something's working well, if the claim is working well, then there is a good dynamic between the insurer, the insurer's representatives, the broker, and the insured. And that's the best way in the end, usually, to resolve these problems. Sometimes there are insurmountable conflicts between them, and that can't be helped. But in most cases, having that positive dynamic, a good flow of information, I think what spooks the insurers normally is silence. When they're reading about things in the press, they're reading that there's some sort of investigation started, they're reading that there's a US litigation that's commenced, no one said anything to them about it. That's the kind of thing that spooks the insurer. And if they're the last to hear about these things, it doesn't build trust with the insured. The insured needs to be as much as legally possible open with the insurer in order to prevent those types of situations. It's a bit like going overdrawn with your bank. You know, if you've talked about it with the bank first, no problem. But if you go overdrawn without saying anything, they're going to be on the phone and you're going to be charged something. So it's about building trust with your insurer. And although your instincts may be not to want to talk to them about things, it is better that you do. And your broker can certainly help with that conversation, and your lawyers can as well. But sometimes the insured's own lawyers can be an impediment to that discussion. So they're kind of warning their clients not to say anything to the insurers. There might be a good reason for that, but it might actually just be overly cautious behavior. Actually, a free-flowing conversation under a non-disclosure agreement That's the sort of way that the industry likes to handle these things.
I hear very often, and I'm turning to you, James, the benefit of having privileged conversations, whether it's at the board level, in terms of like keeping these conversations privileged and ensuring having a solicitor sitting on the board or as a company secretary, to ring fencing these discussions. What about these discussions? I mean, as Ed was suggesting, in terms of engaging with the insurer, in terms of like keeping them informed. I mean, there's a limit of what you can share without putting yourself at risk from a legal standpoint. How do you advise clients on that?
There's common interest privilege that exists between an insurer and an insured, which I think you can rely on quite heavily. And that's certainly our house style is we're very happy to enter into NDAs because that common interest privilege there already. Usually an NDA doesn't add anything. It doesn't. It's not usually required, but if it makes the lawyers on the other side feel more comfortable, we're very happy to do them. And it does differ very much from jurisdiction to jurisdiction. In the US, it's perceived as much more an issue perhaps than it is here. And so I think because so much of our work does have that cross-border element to it, trying to explain common interest privilege and understand how under, for instance, an English law policy, common interest privilege might work and whether it clashes with that when you go into the US or into Canada or somewhere else, is a big part, I think, of where we try to get people comfortable. And I think maybe just a sort of, I suppose, a little shout out here for this line of business, D&O, particularly in insolvency situation. Certainly everyone around this table recognizes we're not now dealing with a company, we are dealing with actually a person and a person's liberty or a person's asset. And you do find that there are perhaps, I think, many less real disputes in this area than there are in some other areas, because everybody understands that there is an individual at the end of it who hasn't had to deal with this before, is being advised. Sometimes we're trying to coach their lawyers as much as them about, well, actually, what is this line of business? And again, another reason why I think having really good claims handlers, really good brokers involved is that coaching element of the lawyers who may never have had to deal with this before. But it is, I think, a class of business in insurance where everybody is really striving for that end game to help an individual.
So we've learned a lot from the input and your experience that you kindly shared with us in terms of like making sure that you have a clear understanding of how the policy works. And I mean, that's one. But can we turn now in terms of the other lessons learned in terms of whether for the underwriter to not having spotted that something was happening, and the same learning for NEDs, non-exec directors, to identify, to be able to determine, should I stay on this board or not? So what were the telltale signs that were missed in that particular case of Carillion, now that we have the benefit of hindsight? Ed?
I haven't read all of the material that's out on the internet about this, but the Parliamentary committee was very critical of the non-executive directors as well as the executive directors. And that is quite unusual for the reasons that Francis mentioned, which is that generally you have these two sets. The execs are right in the middle of it. And by the way, Carillion only had two executive directors on its board at any given time, the CFO and the CEO. They were the only two. So all of the other directors were non-executive directors in Carillion. So immediately you've got actually quite a lot of power concentrated in only a couple of people. And it makes it even more important, I think, that the non-execs are doing their job. But it looks as though from the Parliamentary Committee report that the non-execs were kept in the dark and didn't try that hard to gain an understanding of what was really happening. And that is obviously a red flag for corporate governance. And if you're an investor, that would be a red flag. But of course, people didn't know this. This stuff came out as time went on. If everyone knew that before the collapse happened, then things would have changed. So really, you tend to only find out about these things once something's happened. Bad corporate governance, I think you've told me this, bad corporate governance everyone spots. No one spots good corporate governance because it works. It's only when you have a collapse that everyone realizes the corporate governance was terrible. So there aren't too many things you can learn. The corporate governance code is being proposed to be updated again with more protections. But in the end, it's not going to stop determined directors from keeping the Neds in the shadow. You know, they'll do what they can to hide some of the problems that they've got. I'm not sure that the Carillion executive directors, you know, this is still being litigated. It's been said that they acted recklessly and in knowing disregard, which is pretty serious. But I also know from the reports that the financial information and the reporting in internal reports coming through to the board were not of very good quality. And so the management can't do its job if it doesn't get good information about the health of the company. It's possible that those were contributing factors to what actually happened. And you know, what the Neds can do is help straighten out things like that. You know, they can see that reporting lines aren't clear enough. They can see that the quality of board papers, the financial information coming through. They're on the board. They're going to get a board pack for every board meeting. They're going to see the financials. They could be saying, you know, from my experience of being a Ned in another company, this just isn't good enough. This type of information, it doesn't give me any comfort that we're okay. But I think that what happened in Carillion is that the Neds got bound up with all of it and weren't independent enough potentially, and so they weren't able to give that sort of scrutiny that was called upon, that would normally be called upon in a public company.
Yes, it's going to be very interesting, isn't it? I agree with everything you said, Ed. How all that gets under the spotlight when these directors' disqualification proceedings, assuming they're not settled fully, get underway, which is, I think, due to commence next month, or October, middle of October.
So maybe by the time you listen to this, you'll have an outcome.
The other thing is to do with financial complexity of some of the underlying business that a company such as this was involved in. It's not just Carillion, but other financial services companies. Again, with the 2008 crash, we saw, you know, credit default swaps. In the case of Carillion, it's how you go about recognizing profit on very complex, large construction projects. And what the non-executive directors are no doubt saying, which may be the same as the insurers were saying when they decided that they were going to grant cover to Carillion, is, well, we looked at the financial statements. And yeah, they were pretty complicated. There were lots of notes to the accounts. But at the end of the day, KPMG, I think it was, signed off and said this was a true and fair view. And you know, we as non-executive directors, or perhaps we as insurers, can't be expected to drill behind all of these complex notes to the accounts. If that's what KPMG say in their wisdom, they're the experts. We are entitled to place some reliance on that. That's not, we're not, some of us, this may or may not be the case in Carillion, I have no idea, are not financially, we have no professional qualifications in finance. We're not accountants. We're on the board for other reasons. We bring other skills, and it's not our job to second guess what the auditors in their wisdom are prepared to accept based on assurances from the executives. It tends to be the way it goes.
So before we turn to James and Owen in terms of whether they spotted some telltale signs, I mean, if I may, from already the two description there, could I maybe offer that the fact that when a CFO resigns and he's only one of two executive directors on the board, maybe as an NED is to have a post-resignation interview with that CFO saying, can you tell me a little bit more why you're leaving? I don't know. I'm just offering this as one. The second one, I think, Ed, at some point you did mention that, you know, the auditor had been appointed since the inception of the company.
Right.
And I believe that, you know, in terms of all the good governance advice that everybody keeps giving to everybody, you know, I think considering replacing or changing the for no fault, but changing auditors is a good practice. So to me, that might be a second telltale sign. That's
the job of the audit committee to manage that relationship, and that is chock full of non-executive directors. It is chaired by a non-executive director, the audit committee, and that's the whole point. So how KPMG came to be the auditor for, you know, the whole 17 years of Carillion's, 18 years of Carillion's existence, is an interesting question. KPMG were incidentally investigated by the FRC and were fined over £14 million by the FRC for their audit failings.
On that particular case.
On that particular case, and the findings are very egregious, and the number of individual partners were also fined from KPMG, were also fined. And the findings you can read because they're public on the FRC website, but they're pretty damning of the role of the auditor.
And then there was also a civil case, wasn't there?
There was a civil case. They were sued for 1.3 billion, which I gather settled. So we don't know the details of that. Yeah.
James, from your standpoint, any telltale sign that is kind of like be taken as lessons learned?
Well, I suppose one of the lessons learned is if you're one of 6 and only 2 of the directors are execs and the 4 are NEDs, think very carefully about the diversity of skills on that board. And do you have a trained accountant who sits and chairs the audit committee, for instance? If not, why not? And then training as well. I think you need to make sure that NEDs are always updating their training, looking for changes in corporate governance rules. So what does that actually mean? What's happening on ESG? And what is happening around, particularly Carillion, for instance, what's happening around the politics of procurement and how are you procuring these government contracts? Because there the margins were so slim, you needed a massive company to make a relatively small profit. And so I think there are quite some good learnings from Carillion, but actually in that wider sphere, diversity of skills and training that you are given as a NED on that board, I would say are pretty much big red flags. If you're not getting diversity and you're not getting training, then perhaps think again.
It's interesting because I do notice the emphasis that from an underwriting standpoint, the market puts on financial statements. But indeed, if you rely only on that and it turns out to be misstated, then there is really no potential good outcome. And now turning to you, Owen, in terms of like lessons learned, might be kind of like a good opportunity of like mentioning again your fantastic podcast, because there is one about board effectiveness, which actually I think touches upon on all these topics, because at the end of the day, this is where things happen, where governance, where a company keeps its proper moral and business compass, it's at the board. So what can you tell us about it?
Yeah, well, just, I mean, going back to just some of it's all with hindsight now, right? So we look at it and think, oh, this was a red flag. I think the fact that there appear to have been no red flags raised for such a long period of time, where it was just, we can't give bad news, is kind of the theme that comes out of a lot of the interviews. Maybe that's a red flag in itself, that there aren't any red flags. But firstly, just going back as well to the role of the advisors, I don't know whether it's a good defence or not, but I don't know if that, of course, directors have duties to exercise some sort of independent thought process as well over that. Say, yes, I relied on KPMG, but coming to the learning and development point, kind of mixing in with that, yes, but were you just accepting it, or were you actually reading it, thinking about it, challenging it, questioning it? So I just think that's an interesting point that comes out of it. And then finally on board effectiveness, yes, we have talked about this, and Ed was talking about it there. If you think about the board as being like the brain of the body can't function with the right information coming into it, and the brain can't make the right decisions unless it's effective and if it's got the right information. So if crappy information is coming up, then yes, I mean, it's going to be difficult to make the right decisions. And it's all about decision making, isn't it, as well? So having that structure and process in place of how you make decisions is important.
Thank you, Owen. I think it's time now to actually close this file. I want to thank again our panelists, Ed, Francis, James, Owen. Thank you so much for your insight. And stay tuned for our next episode of DNO Files. Thank you. Bye-bye.